some of these huge cases, and they've given rise to some of the investigations that are going on, whether they're antitrust or straight criminal cases, where the United States government and even state and local governments to a lesser degree are going after these big corporations and big companies. And it seems that there's an arms race, if you ask people in the defense industry, who's going to get the next biggest settlement out of a U.S. attorney's office, and what's going to be the next big recovery from a company. And what companies need to know, what I found when I'm out talking to companies, is that even if you don't know you're violating any laws, you need to be ready. And people think, well, we're a legitimate company, we run a legitimate product, there's no reason that we should be concerned. And there are many cases, a couple I'm working on right now, of legitimate, wonderful companies, Fortune 500 companies, who have rogue actors. They have people on their staff who, even with positive and good motive, may be doing something that's opening up the company to liability. So there are things that happen that you don't foresee happening, and I think this last bullet here is probably the most important, which is companies need well-crafted contingency plans and savvy legal counsel. And what I always say is, the doorbell rings or the phone rings and it's law enforcement, and how you react in that next 5 minutes to an hour is going to make a determination of how that case is going to work itself out. We'll get into that in a little more later in the webinar, but I think the contingency plan and being ready, knowing what to do in those first few moments, and at least knowing what not to do, as in don't talk to the government, and knowing whom you should call, those are the things that are most important. I'm from the government, and I'm here to help you. I can't tell you how many times I've had clients come to me and say that's what they were told. And it may be true. They actually could be there to help you. The government's not bad people. We all know good folks that are in the government that are trying to do good work. But it's not necessarily true. Their idea of help may be help you to a quick and easy plea and hopefully not a lot of jail time. Their idea of help may be entirely different than what yours is. And so you can't take that at face value. I'm from the government, I'm from the FBI, and I'm here we just want the truth. We just want to get the truth. We want to help you. And I think this little checklist here, it may be true if you called, if the company, if you have a reason, and we'll talk about some examples later. But one I can tell you is I represent a company right now where the Chinese have been hacking into their computer system because of something that they provide, that the Chinese are putting bugs into the computers to start stealing that intellectual property. And that's sort of economic espionage. You call the FBI, they come out, odds are pretty good that they're there to help you. Now, you may have divergent interests, and that's something we can talk about in the question and answer session. But if you call them, it's probably true that they're there just to help you and you're on the same page. If you didn't call them, it's most likely not true. They're not normally there to help you if you didn't call them. So I talked a little bit about when you call for help, and one of the examples is this data security breach that I've been working on for a company that's being bugged overseas by a corporation in China that really is just trying to get to some national security level technology that they want to steal because they want to use it. And so one of the things that you need to know is how to deal with the government in those situations. And in that case, in a very traditional sense, our client is a victim. That's all they are. They are a victim of international espionage. But the role of the government there is divergent than the role of the counsel for the company. What we want is to protect our IP and to make sure that isn't in any way, shape, or form compromised, and to make sure that the company can continue to do what they're doing. What the government wants, what the FBI and the U.S. Attorney's Office and the Department of Justice want, is they want to be able to put together an espionage case, they want to prosecute people, and they frankly may want to just use this as a bargaining chip in future negotiations with this other government. The goals are not always the same. When the government is not your friend, well, it doesn't necessarily mean that they're your enemy, but it could be. And it's one of those things where you have to sort of see how things play out, and it may be that they come in like this case that I was just mentioning with the espionage. They come in and they think that you think that they're all good and everything's going to be there, but at the end of the day, their interest in what they see for the national security side is different, and all of a sudden, while they're not your enemy, they're not your friend because now you have a divergent interest. Friendly faces, not always equal friends. Just because you have a prior relationship with them, they have their own fiduciary duties to their obligations, or ethical obligations. As prosecutors, they have their own obligations as agents and investigators. just because they like you, just because you know them, heck, you could have gone, my college roommate's an FBI agent, but he's an FBI agent before he's my buddy if we're working on a case together. So you got to remember that they're not necessarily your friends, even if they're your friends. And I think that it's just sort of keep going over and over and over this. If they call you, if they show up unannounced, and if they ask for information, the assumption needs to be that they're not your friend, and you got to make sure that there's somebody there as an intermediary to look out for you, to understand the nuances of those communications.
And I think as Mark likes to say, not everyone's Jack McCoy, right?
That's right.
Right. Not all prosecutors are like on Law and Order. So why you need to be ready, Mark's covered a lot of this already, and that is every enterprise. You have information that is, some may be protected by law, some is sensitive, some is proprietary. You have customers. So you're going to have customer information. You may have customers who are using your products or services in a way that doesn't comply with the law. You have vendors. Vendors may be providing things to you that are not in compliance with the law, whether it's sourcing of materials, export, import issues. You have relationships with any number of people, formal and informal, that can draw scrutiny. You have employees who can be doing things in a rogue basis within your organization. And you have contractors, once again, who have access to your facilities and your enterprise and can be doing things. So even the most legitimate, pure, all-American, do-good enterprise can have reason for law enforcement to become interested in something within your four walls. Now you have, okay, once again, you don't have to be a bad actor, as Mark said repeatedly, to get law enforcement inquiry. And everyday activities can draw attention. Okay, once again, you have information under your control, goods or services. Look at Gibson Guitar and sourcing of exotic hardwoods, and what happened to them when the FBI came and raided or the federal agents came and raided their business. Your business practices. You maybe have somebody who is making bribes and kickbacks contrary to company policy. You can have illicit use of your business assets. Computer system usage for improper activity is something which is certainly not unheard of. Something as simple as a school district had its central file servers and network equipment seized by federal agents because a couple of guys in the back room were engaging in music file sharing, and they took all of the district servers down and took them with them. And your business practices can give rise to scrutiny as well. So how do you find out if government's interested in you? Well, if they want your information, they're going to do one of three things typically. They're going to give you written legal process, they're going to call you on the phone, or there's going to be a knock on the door. And no matter how that comes to your attention, you have to follow your procedures and your contingency plans. If we look at this, let's start with written legal process. Written legal process is really the least stressful. And typically, businesses get legal process every day, whether it's civil or criminal, depending on the business you're in. I do communication service providers. That's a lot of my practice. They get literally hundreds of notices every day about compliance issues, and they're handled in the ordinary course, and they're dealt with. So that is a very, very frequent vehicle to try to get information. But when you get something, the very first thing is figure out what is wanted, and you may have a legal obligation to preserve that information, even if it would be destroyed in the ordinary course. You really need to secure it and preserve it. And then you got to figure out if it is information from a protected class. Well, how do you tell if the information is protected? It gets into what type of information it is and what is in the information. In the communications realm, the information may be protected by the Electronic Communications Privacy Act or the Stored Communications Act. The location may matter, okay? There's laws on disclosure in New Jersey. There's one pending in Texas that says government can't get things unless they follow certain processes to get certain types of information. You may have protected financial information to the extent it applies. You may have HIPAA information. Once again, it goes to what the subject matter of the information is and whether or not it's protected by a different law. And also, are there restrictions on what federal government can compel you to give? Yes, there are. And as I just mentioned, some states also have restrictions.
And before you move on to the next type, Eric, let me just add that I think, it happens a lot when you have cases where you think, oh, well, this is just a written request for information. And I'll give you sort of an anecdotal story. I got a call one time from one of my partners who said, we have a client and they've received a subpoena for a grand jury up in Massachusetts, and we just need to respond to that. Can you help me do that? And I said, well, why? Why? What's going on here? And after a lot of digging and a lot of sort of poking around and a little back and forth with the government, yeah, we weren't just getting subpoenaed because they were looking at somebody that was a customer on the ground in Massachusetts. We were getting subpoenaed because when really pressed, this was the first volley that they were firing at us, and we, the company, were the target of a criminal investigation. And so don't ever sort of be lulled into complacency by thinking, well, it's just a request for documents. This isn't much. If we were really in trouble, the FBI would have kicked down our door. That's not necessarily the way it works, especially in the white-collar world. So be very, very careful about jumping to the conclusion. And Eric's right. It is the least stressful. Getting a phone call or getting, is more stressful than getting a letter. Getting some at your door is even more stressful still. But just because they sent you a letter doesn't mean that's where it's going to stop. And I think people need to understand as a foundational matter that the government is allowed, the prosecutors not as much, but law enforcement is allowed to lie to you. And the government is allowed not to tell you certain things. And so you should not make the assumption that your mind wants to make, which is, hey, this isn't that big a deal.
And I think what's critical with the written is these are excellent points, is that you need to differentiate immediately between what is, because some businesses have routine flow of these things, and then there's non-routine items. The non-routine items you need to be very, very careful of. And Mark's going to expound on this, I think, a little bit further on. But government knows they probably know what they're going to get before they ask for it. and typically, government starts with very innocent questions. They ask for help. They want you to say things that later will be false, or there's a reason they're asking you for information, and you need to be very, very careful. So I think Mark's advice there is critically important.
And I'll just, not to get too far off on topic, Eric, but I'll just add one more thing. Not only do they sometimes already know the answer, but they sometimes already have the information. I just got brought into a case in the Midwest where the CEO of a company and the company have both been charged in a huge federal election campaign case. And one of the sets of charges are obstruction. And all the obstruction and the false statements are coming out of the fact that they already had, the government, the federal U.S. Attorney's Office, already had information from other people. They made a document request to the company, were told that they didn't have certain documents when they, the government, believed that those existed because they had them from another source. They are charging additional charges just for how people responded to those written requests for documents. So don't assume that they don't. I mean, it's like the old saw about a trial lawyer. You never ask the question of cross-examination you don't know the answer to. And quite often, they're already asking for documents and information that they already have.
Excellent. The phone call. All we can say is be wary, be very, very wary. If you get a phone call and it's not something involving imminent life and death, and even then be very careful. They're unusual. You should not really respond to a phone call. If an agent wants documents, get it through written process, get it through written service. And if you are compelled because you believe there is some life and death matter, verify first. Figure out how to contact a law enforcement agency back at a publicly available number and be routed to the person who claims to be who they say they are. Do Google searches, do other things. Try to figure out who you're dealing with. But the phone call, and we encounter these regularly in our practice. The phone call is something to be very, very leery of. So, Mark, there's a knock at the door.
So then you get to the part that I always say. You get a knock on the door, somebody's standing there with a badge, and they say they're with the government. You void your bladder, then what? And the decisions you make in the next few minutes are crucial sometimes to how a case works out. I can tell you sort of all kinds of extremes. I can tell you the case I represented a guy years ago who, when the agent knocked on his door, it was a public integrity case, and they said, "Sir, we're here to talk to you about something." He looked at him, he goes, "I knew you were coming. I deserve to go to jail for what I did." Needless to say, I didn't have a lot to work with him as a client. And it was sort of a foregone conclusion by the time he'd hired a lawyer, because he'd made those statements when the agent came to the door. They will come to your door, they will come to your home, they will come to your office, and they are trained. All the federal agents are trained either at Quantico or at the Federal Law Enforcement Training Center, and they are trained that they are to use putting you in an uncertain, unsteady situation to get to the root of the answers that they want. So they will come and they will say things to you, and they will ask you questions that will assume things that are not true to try to get you to answer them. And this doesn't make them bad people. It doesn't make them evil. It means they're doing their job. And sometimes in doing their job, they get people to say things that aren't necessarily true. And so you have to be aware. You have to understand that these are professionals. These are professionals coming to your door, and they have a plan. They have worked it out. Before a federal agent shows up at your door, they have gone through the scenario. They have looked at the evidence. They're coming to talk to you, and they know what the answers are, and you need to be ready for the possibility. And Eric's the last little line here about the following a checklist can benefit a corporate leader should he or she be served with a search warrant. You have to have a plan. And I don't know a company in America that doesn't have a plan if there's a fire. And I don't know a company that doesn't have a plan if there's a natural disaster. You know where you're supposed to rendezvous. You know who the person is that's supposed to be doing the head count. You know where people are supposed to, what's the phone tree to call family members. You have plans for all of those things. Why wouldn't you have a plan for how to deal with this emergency situation? So responding to a search warrants checklist, it says call your company's response team leader. Well, then you have to have one, right? This takes a little bit of forethought, and I think it's absolutely critical that any company, and frankly any individual, be prepared for how to deal with when this comes. What do you do if there's what I would call a legal emergency? Who is your response team leader? Who do you have setting up? What is your company policy? Do you have one that's written? Are you a company that has written out how you're going to respond to search warrants, what you're going to do, who the person is that's going to be in charge, that's going to be talking to the agent or agents that are in charge? Do they know? What are they supposed to ask for? When agents show up, they will put everybody into a room, assuming they're doing a search, and they will put everybody into a room, and then they will peel people off one by one to talk to them, ask them questions, and interview them. If everybody knows what the rules are, if everybody knows what they're supposed to do, if everybody knows what questions to ask and what things not to answer, it makes a huge difference in where the company is at the end of that search warrant. They're going to take what they're going to take. You can't stop them. You shouldn't try to stop them. You shouldn't interfere with them. But you should know, you should be ready to know, sir, ma'am, may I have a copy of the warrant? I'd like to see a copy of the warrant and the affidavit that supports the warrant. What's the basis for this? May I have an opportunity to review this? I'd like to know, and you have to become an investigator at that point. Are these people wearing jackets that say FBI? Did they show you a badge that says Health and Human Services? What agency are they from? What are their names? Ask them for business cards. Ask them for phone numbers. Is there a prosecutor to sign this case? May I have a moment to call company counsel? And then what I think is the most important is when you get to the next part, which is you don't consent to anything, because they're going to ask you. Sometimes they have a warrant that says they can go in and they can search 3 or 4 computers, and they say, look, I understand you have some stuff in a storage facility. We have a warrant, may we go search the storage facility? Yeah, that's fine. Absolutely not. You don't say that. Well, we're going to get a warrant anyway. Okay, that's if that's what you're going to do, I'll have to call my counsel. I can't consent to anything. You just do it in a very nice way. You're very low key about it, but you don't want to do anything that expands the reach of what they're doing, because what's any good investigator going to do? They're going to try to get more. They're going to try to get more. They're going to try to put more evidence together to make their case. You don't want to give them anything. You don't want to take away the opportunity later, if you have to fight this case, of being able to suppress that evidence and keep those things out. You need to make objections in a timely manner, and the way to do that is to have a plan in place, have everybody understand that nobody should be talking to anyone unless they have a company representative present. You should have your lawyer's phone number, whoever it is you're going to be calling. You should have them, and if it's 7 o'clock on a Sunday morning, sometimes that's when I get phone calls, right? that's when they come to your house. If they come to your office at 9 o'clock or 9:30 on a Monday morning, you better know who you're going to call and how you're going to respond to that and have everybody prepared for that.
And Mark, on the last point on this slide, objecting to unauthorized access at the time of access, and isn't that just so that, you're stating the obvious,
right?
Saying, well, no, you don't have the right to go in there. Well, we're going to go in there anyhow. Well, I object, and that's right. Explain the reason for that, would you?
Well, because what's going to happen is you're going to have, if they're doing a legitimate search warrant, I'll give you an example. I had a company here in Northern Virginia a year or so ago that was raided for conduct they alleged by a couple of the corporate officers. And, the company's probably 35, 40 people. And they showed up with about 20 federal agents. And so you have one agent talking to this person, one agent talking to another person, one agent talking to the receptionist saying, can I look at this stuff? They are going to say that they were given permission to look at anything if there's later going to be a challenge. So what you want to do is you want to have one person who's your spokesperson, you want to have that person in touch with a lawyer, and you want to have that person understand that no matter what they're doing, you're saying, I am not giving consent to this. I'm not going to interfere with you. You say you have a warrant, but I am not consenting to this search. And you want to make sure that that is clear and that multiple people hear it so that that is locked in because, agents are just people, right? And sometimes their memories are as bad as anybody else's. And if they think they remember that you said that they had consent, it's a whole lot better if you've got 15 other employees that clearly remember you saying, I am not consenting to this. On the next page, we talk about being an investigator. I think you be very careful. You have to be ladies and gentlemen, right? You treat them very, very well. You're respectful. Yes, sir, no, sir, yes, ma'am, no, ma'am. But take information down. There were 14 agents that came in. 10 of them were wearing U.S. Marshals jackets. 4 of them were suits. They were white male, mid-30s, ex-height, said his name was Joe. They were a black female, late 40s, wouldn't give a name. Where they went, things they did. Take as much information down as you can because that's all useful later. Because sometimes, and I'm not saying prosecutors are bad people, but sometimes they won't necessarily tell you everybody who was there at the time of a search. Sometimes they claim not to remember, they're not relevant. You want to be able, as your lawyer wants to be able, to be in a position to call other witnesses because sometimes your best witness is another agent who's there who saw or heard something. You can ask them to wait outside until counsel arrives. I don't think they ever will, but it's a legitimate request and it's certainly something good that will help keep your office from being so disrupted. You can ask for a pre-search conference call, and in almost every case that happens, they allow that, and you should do that. You should call that. You should ask to step aside and make a phone call from a private place to talk to your counsel about exactly what's going on. And I have been in that situation where or one of my colleagues has had to jump in the car and race over there to be on the scene to take down this information and figure out what the ground rules are for the search, get a copy of the warrant, get some information, maybe even get the name of the prosecutor who's behind it because if the officer's gotten a warrant signed, then they've gone to some prosecutor who's overseen it. You can ask the company agents. Most of the time they won't let you, but you should always ask, again, because you just want to take mental notes, and you want to have that person whose job it is to sort of be the point of contact, to be taking down as much information as they possibly can. For that reason, the agents typically won't let you. They don't want you to see what's going on, but if you can, you should. You want to monitor the execution. Whether or not they'll ever let you video or tape, I think the answer is they never will, but you could certainly ask. But take notes. Take as many notes, write as many things down as you can. If it's even calling your voicemail and leaving that voicemail of what you're seeing as it's happening, that really can be crucial. Here's the next part what I think is important. Other than gathering information, you shouldn't be providing information, okay? I'm not saying be difficult, don't tell them what your name is, but you shouldn't be giving them any information. If they say, well, where's Joe today? Well, I'm going to talk to counsel before I answer any questions. Well, we just want to talk to Joe. Is Joe in? Is Steve the guy that normally runs this machine? You know what, I'm going to have to talk to counsel before I answer any questions for you. And you just keep saying that over and over in a very, very nice way, very non-confrontational way. But what agents know is that it's typically not on TV the way it is in the real life. Most of the good agents that I've experienced, and I've dealt with a few hundred of them at this point, they're not yelling and screaming. They're not hollering at you. They're not threatening you. They're not putting a bright light in your face and handcuffing you to a table. that's for the movies and frankly not reality. And in the rare times that happens, they're street crime cases. It just doesn't happen in the white-collar world. They are going to be, ladies and gentlemen, back to you. They're going to put you at ease. They're going to get you to put down your guard. They're going to get you to think like, hey, you know what? This is just a misunderstanding. Why don't you explain it to me? And there's a part of you that may think, hey, if I just explain this problem will go away. If they are there with a warrant, I will stake my career that there's nothing you're going to say to them that's going to make them leave. They're going to collect what they came to collect, and they're going to try to collect more information, which is from you. So gather all your non-essential employees, get everybody into a room. If they say, hey, you know, we're going to be at this all day, say, okay, I'm going to send my people home. Try to send them home. Get them out of there. But tell them, and I think this goes back to the plan, it's really better to have told them in advance, to have a plan as part of your training, as part of your employee handbook, as part of your yearly sort of, you know, what things are going on, how we deal with search warrants, how we deal with things here at the company. They have a right not to be interviewed without an attorney. And if they're not comfortable with corporate counsel or having a company attorney, you can get an attorney for them on their own. But they need to understand, and I'll give you a perfect example that just happened within the last couple months. The number 3 employee of a company they represent, that we knew that there were problems coming, we knew things, you know, had happened in other states, had told them over and over and over and over again, this is a problem, we need to have your people prepared. No, they're good, they know what they're doing. Agents went out, they raided the company headquarters, and they sent out agents across the country to 35 or 40 different individuals' homes all at the same time. They all happened at like 8 o'clock on a Wednesday morning. Multiple states, completely coordinated. And an agent sat in the home with a number 3 employee and said things to him like, this is a really nice house. Hate to see this thing forfeited. Can you tell me what was going on at the company? Hey, you know, these are felonies, and sometimes wives get charged. Isn't your wife a Brazilian national? I mean, literally sat in his living room telling him that. Oh, but you're not under arrest. Until he got a signed statement. Would not leave because the client's employee hadn't been properly educated to feel like he could say, I'm not comfortable talking with you, please leave my home. And if you're not under arrest and they're not serving a warrant on your house and searching your house, you can ask them to leave and they have to leave. You never, ever, ever have to talk to them. Okay? You never, ever have to talk to them. So, and I think the last part is the press. You know, people sometimes think they get, you know, walk out the door and there's a camera out front and they think they should say something, and it's really important that people understand that what you say to the press, whether it makes it on the news or not, can just come back to bite you, and you need to control that information that comes out. On page 20, it talks about protecting privileged data. That is something that is more sort of in Eric's wheelhouse, and I think that it's really sort of important to make sure that you know about your electronic records, and depending on what your company is, I can talk to you individually about, you know, different companies have different places, you know, whether you want to have an off-site cloud, because if they seize things, like say they come in and seize all of your servers, and I've seen that many times, well, your operations basically cease. You say, well, they just need these for grand jury. Why can't they just copy them? Sometimes they will. If it's a Secret Service, they're pretty good about coming in, and they'll image everything, and they won't actually physically take your servers. Other agencies don't have sometimes the technology. State law enforcement typically doesn't, and they will just literally come in, unplug your server, and they will take it. And you will wait 3 weeks, 2 months before they decide if they're going to charge you and whether or not they're able to get it copied and get it back to you. So that's 2 months you're not working. So having a part of your plan is depending on what your data is and what your company is, you may want to have a contingency for a backup that is in existence at another location, so you can keep the wheels turning and business running as normal while this is going forward. I know I'm saying the same things over and over and again, and I apologize, but I think some of them are just so important. Ask for a copy of the affidavit. If they won't give it to you, ask them why. And again, when I say ask them, I'm talking about the designated person at the company who's going to be the front person until legal counsel arrives, or can hand the phone over and let legal counsel talk to the lead agent. You can ask questions. Ask questions. Is the company a target? Is the company a subject? Is the company a witness? What can you tell me? What court is this in? Who issued this warrant? What is the allegation? What is this? You know, who is the lawyer for the government that I can talk to? And then, again, the last one is maintain your own inventory of documents seized. Take very careful notes, the best you can, about what's being taken and where they're going. Because as you see on the next page, they'll ask you ask for an inventory. It's called a search warrant return. They have an obligation when the government comes in, state or federal. They have to tell you what they've taken. They can't just come in and take all your stuff and say, okay, see ya. They're supposed to give you a copy of the warrant. They're supposed to let you see exactly what they took. Okay, they do it. And if they want it to be evidence later, they have to do that for their chain of custody. So they will do a search warrant return. They may give you a sort of half-done job of a search warrant return. It says, 4 boxes, main conference room. That's your opportunity to take notes. Say they took a blue box that was all of the 2012 receivables. They took a green box that was all of Jane's, accounting information for the audit. They took a brown box that said, for Steve's expense reports. Keep all of that, okay? Take all that stuff. Don't sign the receipt for the inventory. Just accept it. Take it from them. You don't want to, in any way, shape, or form, think that you are endorsing what they've taken or you're agreeing to it. Because especially if they've come into your company and taken a lot of stuff, it may be more than you can even take down at one time. But just take down as much as you can. If they want, and this is more for the checklist, if they want to interview you, you want counsel. You want to have somebody there. You want to have somebody sitting next to you, because I can guarantee you there's going to be 2 agents talking to everybody that they're talking to. There's going to be one agent who's asking most of the question and the other agent who's going to be taking the notes. And they're doing that so they're not left with your word versus their word. They're left with your word versus 2 of their words. And so the agents, the FBI calls them 302s. The agent will take down, if they sit down and talk to you for a couple hours, they'll take a couple hours worth of notes, and then they'll go back to the office, and they will turn that into a report. It's called a 302. The IRS, and they call it a MOI, Memorandums of Investigation. Sometimes some of the agencies call them ROIs, Reports of Investigation. They're all the same. They are not verbatim. They're not a transcript. They don't tape these, but they are their impressions written out in a sort of shorthand form turned into a report. That will then be the version of what you told them. And I will tell you, having done this thousands of times, it's never exactly right. It's never exactly right. It's never as good as having a transcript or an audio tape. So it's never in your benefit to give them that information. You can give them that information later the same day with a lawyer sitting next to you. You can come in next week and give them that same information. The information won't change. They will cajole you. They will try to sweet-talk you. They will say things like, hey, listen, this is the best way to help yourself out. You really help the company if you just answer these couple questions. If you just give us information, we might be able to sort of resolve this thing pretty quickly. And I've had all of those scenarios and all those things said, and those people still end up getting charged sometimes. So don't volunteer information. Don't submit to an interview. And don't authenticate any documents. You don't have to do any of that. If you are a witness, they can subpoena you. If they're going to subpoena you, they're going to subpoena you either way, and you go in with a lawyer. If you are a subject or a target, you have a Fifth Amendment privilege, and you would be crazy to waive it. So you can't talk them out of it. When they get there, they've already gone through a number of hoops. They've already gone to a judge. They've already asserted they've got probable cause. They are not going to change their mind. Okay? They're not going to change their mind. You can't talk them out of it, so don't try. On the last page of this section, I say don't do anything that would be interpreted as obstruction. Don't get in the way. Don't argue with them. There's no percentage in it. Just be courteous, cooperative, and quiet. Ask the questions you can. When they tell you to shut up, you shut up. And you just keep asking things. And then the summarization of the search and a memorandum of counsel, that's going to be the crucial. You got to get that stuff down while it's still fresh in your memory. And now you've got to turn it over to lawyers. But the best thing you can do in a situation when they show up and they start taking your things and asking questions is you cannot make it worse. And the way to not make it worse is to say nothing. And what I tell people is, I've been doing this, 16, 17 years now, and I can tell you that if somebody came to search my house or come and ask questions of me, and this is what I do for a living, this is all I do every day, all day long, 365 days a year, I would not answer those questions, because if I answer them, it's an admission by me. I would want somebody else, somebody who's a lawyer representing me, to answer those exact same questions and not be making admissions that will be later used against me. So no matter how smart you are, no matter how good you think you are, no matter how right you think you are and how wrong you think they are, there's no benefit at that moment to having that discussion.
And for those of you who ever have the pleasure of visiting Mark Schamel in his office, he has a very welcoming doormat. It doesn't say welcome friends, it doesn't say good day. His doormat simply says come back with a warrant. So good advice, Mark. What I want to do is cover quickly, and this applies beyond communications data. Every enterprise has a vast treasure trove of communications data in it, which has potentially distinct legal requirements as to what you can and can't disclose. But these rules apply to other types of data as well, as far as what may be in the content of data, and we'll cover that in a moment. But if you have a proprietary communication system, meaning you're running your enterprise email, you have an internal voicemail system, those are subject to some outdated federal regulatory regimes, principally the Electronic Communications Privacy Act, the ECPA, the Stored Communications Act, actually it's not Privacy Act, Stored Communications Act, and the Wiretap Act. Those have been subject to numerous proposals for change and modification over time, because now that we're in a digital IP world, these acts don't capture in a concise way how information is protected. So we do have federal legislation that may change this. For example, there is a third-party warrant requirement bill that's out there that says, look, if you're a communication service provider and you have third-party information, you can't give it to government unless government produces a valid search warrant. State requirements, for example, same thing. Texas is about to have a bill signed that would require that as well. And your system, you have an internal email system, let's say, and the Electronic Communications, Stored Communications Act, those statutes apply to you. But don't confuse, and you may say, look, I have user agreements. All my employees who use this sign an agreement says I have access to everything that's in there. You have no expectation of privacy. I can get any data that I want. That's one question, okay? Can you, as a provider, get the data of your users and do whatever you want with it, okay? If you've got your policies properly crafted, the answer is yes. Is it easy with employees? Yes. It's a little bit more difficult when you have a contractor. Say you're an insurance company and you have agents, you know, who are not employees, but they're third parties, but they're using your proprietary email system. Yes, then you're a little bit more complicated. But just because you have the right to access information doesn't mean that you necessarily have the right turn it over. When we deal with the ECPA and the SCA, those deal with the rights of government to come in and compel you to disclose communications-related data. Okay, and there's a vast array of communications-related data. It's just if you read in the press about what NSA is doing, they're saying, well, we don't grab the contents of information, we just grab the metadata. Well, metadata is protected, contents are protected, and law enforcement will go after various pieces of the communication. And the method of service, for example, matters. Under the ECPA and the SCA, it depends. An administrative subpoena can get some information, a warrant can get other information, a court order can get even more information. So the way in which you're served and the data, because certain type of metadata can be had with an administrative subpoena, other type of metadata that is more sensitive can only be had with a court order, for example. And when you get to the contents of the communications, then you have other, you have a variety of standards that we'll get into very briefly to at least introduce them. You may also find yourself subject of national security letters, where the FBI can go after by sending you a letter, effectively administrative subpoena, certain financial, transactional communications information. They issued 21,000 in 2012 since the Patriot Act was enacted. They've issued over 300,000. There's widespread documented abuse by the FBI of NSLs, but the threshold for getting an NSL issued is so low that they're very hard to challenge in court, and most companies don't try to challenge them because it is very difficult to, and you really, it's a low prospect of getting one overturned, and you make a lot of people in some very high places unhappy. Foreign intelligence surveillance court, that's mostly for communication service provider. That is in and of itself a very unique situation, and if I would ever tell you that I dealt with one of those or more than one of those, I'd be in violation of federal law, so we can't talk about those. But if you do have a FISA court issue, we do have experience with those. Where the data matters. Is it stored or is it in motion? You notice we've got two acts here. We have the Electronic Communications Privacy Act that governs with data in motion. You have the Stored Communications Act that says it is not in motion. And as you know, IP transactions run through a variety of transient servers. So for a moment, for a millisecond, data is stored in a particular server. So is it covered by the eCPA or the SCA, and which protections apply? A lot of litigation over that. But the location matters as well. For example, if you have a fixed drive in a server, physical server or a computer, that has different protections than if that very same data is in a cloud. So if you have an email that is stored on your email proprietary server, that is a different level of protection than is afforded your Gmail on a cloud server. If you have a mass seizure in the search warrant scenario that Mark was covering, it doesn't give, they may be able to seize a server, but that does not give government the right to access everything on that server, and you need to seek protective orders. And a lot of it goes to what is the content of that data, what is in that data. Even when you get into an email may have, and once again, it all depends whether or not you're covered under HIPAA. If it may have personal health information, it may have banking information, it may have it may have privileged communications that Mark talked about earlier, and so the type of data matters when you look at the contents. You can't simply say, look, I am going to voluntarily, I am the email provider, I am going to voluntarily comply and give this to the government. If in fact the government doesn't have the right to compel the disclosure, you may be prohibited by a maze of different laws from just voluntarily handing the information over. So one thing you need to think very hard about culturally and procedurally is, are you going to just voluntarily comply with every government order to provide information that comes along? And we go back to one of our very first slides, which is the government is not always your friend. So you need to be very, very careful about voluntary compliance because you may be violating other applicable laws. Opened or unopened communications. And open communications that's retained has less protection than an unopened communication that is given greater protection under the law. This isn't a Byzantine maze of provisions as far as the type of data, the status of the data, where it's stored, how old it is. So just be cautious when turning over communications data, and this goes for voicemails as well as emails, anything that's stored on your system. Objections, notoriously hard to lodge. You can, and you even if you have a right to object, once again, it's a hard bar to. It's such a low bar. It's hard to get them overturned. You make friends with people in important places very unhappy, and you really don't have any skin in the game. Now, the question is, if you get a target, if you get a request for information or demand for information from law enforcement about a particular target, can you or can you not notify that target? Once again, the eCPA and the SCA govern all that. In some cases, you have to tell them. In some cases, you can't tell them. And don't forget your state law considerations. So this has been a very quick overview. It's a very fact-specific area, but you need to be very careful when you get requests for production, especially from the government with respect to communications that you host on your system. And in the last 10 minutes, we want to turn back to Mark and talk briefly about witness rights.
Eric, I'm going to run through a little bit of sort of in a broader stroke because we've only got 10 minutes left, and I do want to leave this open for a lot of questions. Let me tell you what the next couple of slides say.
Hey, Mark, let me just remind the participants that if you have questions, please type them in to make sure that we get them. So if you have questions as Mark's talking, please send them to us so we can process them.
Absolutely. I mean, we can listen to ourselves speak, or we can listen to your questions, which I'd much rather do. Let me tell you about sort of just generally where this is. This is the rights you need to know. And what agents will do, and I've actually only seen it done on, I always refer to television. I think that's where most people get their ideas about about what's really happening in the world of law enforcement, but very few TV shows do it right. But unless you watch Breaking Bad, and I was watching that recently, and I came to it late, and the DEA agent in there, Hank, said, well, just answer, I just have a couple questions for you. He said, well, I'd like to talk to lawyers. You don't really need a lawyer. They sort of complicate things, and let me just, that is, first of all, it's crossing the line. You've asked for a lawyer, it should cease immediately. But that's the way that they're going to come after you. Unless there's somebody's life on the line, unless there's a bomb planted somewhere, there is no time clock that's running. This is no shot clock. It doesn't have to be done. But what they know, what law enforcement knows, is if they talk to you cold and they can get you to answer questions before you've had a chance to sort of figure out what's going on, get your head on straight, start breathing normally again, and get a lawyer sitting next to you to get you prepared, maybe just to go in and tell what you know, it's not a big deal. You may go in and do that. But they know that if they don't let you have that opportunity, if they catch you like a deer in the headlights, they can get you to say things, they can get answers, they can get information that they're otherwise going to be denied. And so you have to understand your rights. You have to know they have a right to ask, you have a right to say no. They have a right to say they're going to subpoena you, you have the right to say, okay. If they're going to subpoena you, they're going to subpoena you anyway. I do this all the time. I go and talk to witnesses, and I'll say, hey, listen, if you could talk to me for a couple minutes, depending on what you say, I may not need to subpoena you. And that's true. I may not need to. But odds are, when I hear what the witness has to say, if it's good for me, I subpoena them anyway. And they say, well, I thought you may not. I said, yeah, I thought I might not to, but what you said is really helpful, and I may need you for trial, so I'm going to need to serve you with a subpoena. The government does that too. They do it all the time. And they say, oh, I'm going to have to give you a subpoena. So they give you a subpoena. Say, all right, now tell me what you know. Well, a subpoena isn't to answer questions in the foyer of your home. A subpoena isn't to answer questions in the parking lot of the grocery store. A subpoena is not to answer questions in the boardroom of your office. A subpoena is to appear at a specified date and place and to give testimony under oath. That's a future place. They cannot subpoena you to that moment. And if they subpoena you and say, well, you're going to have to tell me anyway, that's great. I'm happy to tell you. I'll be there with my lawyer. Thanks so much. And that's all you say to them. You don't answer the questions. Nothing good ever comes from answering the questions. You're still going to have to answer them under oath. Why would you do that without having somebody to help you get prepared and make sure it's taken care of? If you look at the next slide, it talks about it, 2 slides later, I guess, Eric. It talks about it being a threat of a grand jury subpoena. Look, if you're just a witness, it's not a threat at all. It's an uncomfortable afternoon at the grand jury, but it's not a big deal. If you're a subject or a target, they're not going to put you in a grand jury anyway, right? Because you're going to want to invoke your immunity. So if they give you a subpoena, it's fine. It's not cancer. It's not going to ruin anything. Just you say thank you, you take the subpoena, and you say you'll be in touch. Have a nice day. The investigator doesn't have the subpoena power. Agents don't issue subpoenas. Prosecutors do. So if there's a grand jury investigation that's already going, all the more reason not to talk to them. All the more reason not to answer questions. If they do the informal interview and they do that right up in that report, they're going to say that's what you said, and they're going to say it's verbatim, and they're going to say it's 100% accurate, and they're going to expect you to say the same things under oath when you come into the grand jury. Wouldn't it be better to refresh your own recollection, talk to your lawyer, look at emails, figure out exactly what your memory is before you commit to something to a federal agent? If you do submit to a federal agent interview, you have the right to decide when and where. They say, well, we want to talk to you. Great, I'd love to talk to you. All right, well, we want to talk to you informally. Fantastic. We'd like to do it now. Now it's not a good time for me. I'll tell you what, give me your card, and I'll get back in touch with you. I'll have my lawyer call you, and we can do it maybe tomorrow or the next day. Well, no, now I really only need 5 or 10 minutes of your time. Yeah, just not a good time with me, and I'm really not comfortable doing it without talking to counsel first. So, but you're not in any trouble. You're not a subject. You're just a witness. I just have some questions for you. That's great, but I'm going to talk to company counsel. I'm going to talk to my own counsel. Now's not a good time. And you stick to your guns. But when and if you ever do have a conversation with the police, with the law enforcement, the simple answer is you tell the truth. Question number 1 is, do you talk to them? If the answer is yes, question number 2 is, do you tell them the truth? The answer is always yes. You never, ever lie. And I use the Martha Stewart example because Martha Stewart did not commit a securities violation. She was not an insider. She could not have been charged. But she went in and met with the government. She talked to the FBI. They charged her. They convicted her, and she went to prison for lying to a federal agent. It is a federal offense to lie to a federal agent, to make a knowingly false statement. not under oath, just talking to an investigator in the course of their investigations is a 1001 violation. So you have to tell the truth. This next block that just talks about, not destroying or altering any documents or evidence. You just got to hang on to it. You just hang on to it and give it to your lawyer and let them decide what gets turned over for a grand jury subpoena. Let them do the date stamping. Let them cover privilege issues and everything else. Don't do that for yourself. The last thing is, when you do have your interview, and this is the stuff your lawyer will know, to get a copy of your prior statement, find out if it's being recorded, and have a lawyer with you. I mean, there's just no downside. And I know, because I've heard it a million times, and I hear that even from the law enforcement agents that I represent. Well, only guilty people need lawyers. And I always hearken back to the 387, I think is the last number, 380-some people who've been exonerated off of death row for crimes they didn't commit. So no, not just guilty people need lawyers. Everybody's entitled to one, and you should use one.
So when we look at this in a coordinated fashion, you've got to really factor two things in. Number one, you got to address issues from the privacy perspective, and I suspect most everyone on the phone is a privacy professional, and that's why you're here. And then you need to integrate it with advice from a white-collar defense lawyers. I mean, this could be INS knocking on the door. It could be, customs knocking on the door. It could be the IRS knocking on the door. I used to own my own law firm, and we closed. I went to work for a boutique firm, and my accountant died of a heart attack. Well, he never filed the form. He never filed the ending withholding tax statement. So, I had IRS knock on my office door one day, come in and say, "We got to talk right now because you owe a whole bunch of money." So, the most innocent of things can cause investigators to come knocking on your door, and they think they've already got you before they knock on the door. Most importantly, these steps to take, and I can't stress these enough, is have a compliance and contingency plans and systems in place. Know what to happen. We know that things happen routinely. We know things happen not routinely. So be ready for and have compliance mechanisms in place for the routine requests. We talked a fair amount or a little bit about the eCPA and the SCA and what do you need to do, what do you need to know if you are an enterprise server provider of emails and voicemails and phone systems. We have matrices that are set out that tell you what to do for different types of requests, what you can and can't do, what metadata you can and can't give out. That's not rocket science. It's not easy. It's not simple, but it is schedulable. It is procedural. It is understandable. You can do it if you have the systems in place. But then to Mark's point, and Mark, maybe you want to cover these last 2 points, is once again, knowing what to do when that knock on the door comes and you have agents at the door. And compliance lists, because I think we have compliance lists on those things too, correct?
That's correct. We do. I mean, and I think some of them are company specific. If you work at a company of 30,000 people, you have a much different procedure than if you work at a company of 30 people. But I think everybody needs to understand sort of the way they deal with outside, and you can do it in such a way, because I know a lot of companies are reluctant to say, well, this is what you do when you deal with somebody coming in to raid us or serve a search warrant on us. People go, well, we didn't do anything wrong, But in the reality, in the new sort of post WorldCom, Enron, Sarbanes-Oxley world, there's a much different focus, and a lot of companies are getting these requests and getting warrants, and you need to have a plan. And I think you can sort of enmesh that into, this is what happens when the press comes. This is what we have a plan. You don't talk to anybody until you talk to person X in the chain, and then person X is the person that we can have prepared to deal with that issue and be the person that picks up the phone and calls outside.
So we don't have time right now for questions, and but I want to make sure that 2 things. First of all, that you join us next month. Ted Claypool will be giving the presentation February 12th on privacy and biometrics, faces, fingers, and algorithms. And that will be another great presentation that Ted's going to head up. And then you have Mark's and my email and our phone numbers. If you have questions, please email us, and we'll respond as we can. And we're a little bit over our time limit, so we
let me just say one thing, if I could, before you say. Yeah, my email's on there, and I'm really good about responding to emails, and I feel very strongly that if I could have the time I just had with every single person on this phone, with every person in America, I can drop the conviction rate down by about half. So I am all about helping you out to get something in place. If you have questions, if you want go-bys, I'm not looking to charge you or anything for that. I'm happy to share, so please reach out. I mean, there are questions. Feel free. My email's there, and I'm happy to respond. Thanks, Eric.
Okay, and if you do talk to Mark, you know, even though I don't live in the same state as Mark, if I get in jail, I'm calling a cell phone. If I get her picked up on a Saturday night, I'm calling Mark Schamel. So thank you all for your time, and if we'll leave the question box open for a bit. If you have questions, send them, you know, see if the webinar is still up. We'll leave it open for a few minutes, send it up through there. Otherwise, send it to Mark and or me, and we'll get back to you. Thank you very much for your time.